Good morning. Good morning, everyone. I'm just going to wait for you guys to trickle in. Hi, Instagram. Hi, YouTube. And hi, Facebook. I got a good topic for you guys today. Just going to wait for you guys to tune in. How's everyone doing? Um, Let me introduce myself real quick. So, my name is Aisha Chirowe, and I'm an immigration lawyer. I represent clients in all 50 United States and internationally if they want to immigrate to the United States. We handle mostly humanitarian based immigration cases as well as family based immigration cases. So, VAWA cases, T cases, U cases. This is obviously our area of specialty, but we still handle other cases like marriage-based cases, fiancé visas, filing for your siblings, your parents, your children, motions, to appeal, removal cases if you're interested in like a 42B, or VAWA cancellation. So these are some of the things that we handle. Good morning, all of you. If you want to schedule a consultation, you can call 407-995-6567. Maddie says, I did send you a message. You didn't reply or you didn't reply. I'm sorry. I have, over 70 something thousand followers. So I get a lot of messages. And a lot of times, I think I wrote it on there that you should actually not DM us. It's better for you to call. Just because I can't keep track of all those messages. If not, I won't get any work done. I would never be on live. I won't be able to do any consult or work because I will be responding to messages. So if you want to schedule a consultation, your best bet is to call the office. Someone is asking, how much our consultations. It's $150. And our number here again is 407-995-6567. And then you can text us on WhatsApp if you want someone to call you back to schedule a consult, 404-333-8751. We don't schedule consults on WhatsApp, but we can call you back to schedule it. Okay. Let me just put my phone number in here real quick, and then I will get into the topic. 6567 or WhatsApp. Guys, I've told you guys like a million times, it's so hard for me to type numbers and talk at the same time because I don't want to type the wrong number. So just give me a second, Instagram and Facebook, to enter those numbers and pin it. 8751, I think is the number. And then if you're on Facebook or YouTube, was it 404-333-8751? Yeah. If you're on YouTube or on Facebook, you should be able to see my number. It's kind of like scrolling through the ticker that way. And if you're on Instagram, it's pinned down for you. And you can also, when I get off, you can also just check our profile. The number is in there. So today I really want to talk about good moral character and the requirements, and sort of, if, a lot of times most people that ask about good moral character, have some kind of tint or taint in their records, and they want to know how they can overcome it or when they can overcome it or if it's a deal breaker. So I think today's topic is a good topic. So when you submit a VAWA application, real quick, a VAWA application is Violence Against Women's Act, which is an act that allows both men and women to submit application for a green card based on abuse. If they're married to a U.S. citizen or a green card holder, or they were married and the divorce hasn't been up to 2 years. It also allows children to file for the same if their parent or step-parent was abusive or extremely cruel, and then for parents. But the only difference is that with parents, you have to be, the abuser has to be over 21 and they have to be a U.S. citizen, the child. So you can submit a VAWA petition if your child is a green card holder. And one of the key requirements to get approved is that you must prove good moral character, right? You have to prove good moral character. So what is good moral character? USCIS typically takes a look at, you don't have anything in your record that USCIS considers a bar. And I'm just gonna kind of like, I have a list today that I'm just gonna kind of list out some things. Obviously this list is not exhaustive, but I think that it would give you guys a really good idea of what good moral character is not. So for instance, like people that will have a hard time or they'll be barred, from good moral character, and I'll get into waivers in a second, would be like someone that's a habitual drunkard. Like, so if you're a drunkard or like, you have several DUIs, they can infer from that, maybe you drink a lot. If you've been engaged in prostitution within the last 10 years before you filed, and engaged in any kind of commercial vice, not related to prostitution, involved in smuggling people into the United States, like if you're ever like a coyote or any of those types of things. And then if you've ever been convicted or have admitted to committing a crime of moral turpitude, there are certain exceptions to those moral turpitudes. So things like purely political crimes, a petty offense, or a crime that was committed when you were under the age of 18, or that was more than 5 years ago before you applied for citizenship, for a green card. So those ones, are kind of like the exception to being barred from good moral character. And then there's, of course, conviction of 2 or more offense, where when you add the total number of sentencing to prison or confinement, it's 5 or more years, definitely a bar. If you've ever violated any controlled substance laws, there is an exception, of course, simple possession of 30 grams of less of marijuana. But, otherwise, you're looking at a bar to good moral character. And then if you're earning income derived principally from illegal gambling, or you've been convicted of 2 or more gambling offenses, a person that gives false testimony for the purpose of obtaining immigration benefits, if you've been incarcerated for more than 180 days, as a result of that, conviction. And then, of course, conviction of an aggravated felony, which is another whole section that we can go into. And then, the last one is engaged in, thank you. My name is Chooks. Thanks. And then the last one is if you're engaged in polygamy, because you guys know polygamy is illegal in the United States. I know like polygamy is okay in certain countries, especially countries where they practice Sharia law and there are Muslims, but it's illegal in the United States. So when they're looking at good moral character, and even though I've listed all these things, there are definitely some things on this list where a waiver is available. So as you guys know, that almost every law, there's always an exception to the rule, and so while they're looking at you for good moral character for the last 3 years by showing that you don't have any of those bars, if there's anything on this list that you have, the things that we have to prove to USCIS is, one, we can show that there's a waiver that is available to you, which is, so even though this thing is would be typically a bar, that there's a waiver available. And then number 2, that the conviction was connected to the abuse. Kwame says she's Ghanaian, not Nigerian. I don't know if you're talking about me, but I'm Nigerian, 100%, green, white, green. I'm not Ghanaian, but shout out and love to all my Ghanaians out there. Okay, back to what I was saying. So when you're thinking about waiver, I'm just going to throw a few things here that you might be eligible for a waiver for, like, the habitual drunkard or prostitution, or if you've ever given false testimony and stuff like that. These are some things that you can request a waiver. I mean, a waiver is not easy to get, but it's not impossible to get as well. You have to show that, hardship to yourself. So in other categories of immigration, like let's say you're filing a marriage-based case and you fall under one of those things, when you're doing a waiver request, you want to show hardship to a qualifying relative. And sometimes the qualifying relative has to be your U.S. citizen or green card holder parent or spouse. And certain cases of crime of moral turpitude can be a child. With VAWA, you don't have to have any other qualifying relative other than yourself. You have to show extreme hardship to yourself if they don't grant you this waiver, and you have to be deported. So, it's one of those things that, things happen, people do things that they regret. And, it's sad that they don't know that those things can cost them like a permanent bar. But there's certainly waivers. And, if you're definitely one of those in those situations, we're happy to evaluate your case, and, see if a waiver is available. And of course, fight for you, because I will tell you, like, we've probably had people in several of those categories, not all, several of those categories that we've been able to help if a waiver is available, if the timeline has been much further out and we can show, that person's character, because there are many ways that you can redeem one's character, over the last, few years, showing that you're a good person. And then also, if you've entered into the United States, and you file like for VAWA, maybe before the 3-year timeline, usually they're going to want proof of good moral character from your home country. So let's say you came into the US in 2022, since we're in 2024, and you submitted your VAWA this week, next week, or whatever it is. So you're only going to have 2022, 2023. So they're going to want to go back as far back as 2021. So the onus is on you to at least try to, start looking for, evidence or police clearance or whatever from your home country to show that, you have good moral character for the requisite year. Nabora says, hi, me as your paralegal. Send us a DM or send me your resume to my email. Let's see what you've got. Andrew says, is there a statute of limitation on the crime, i.e. if it was 15 to 20 years ago? It depends on what the crime is. Like certain crimes like murder, there's absolutely, like, it's forever. Like you're looking at a permanent bar. If the crime has been 15 to 20 years ago, it depends on what the kind of the crime is. Certain crimes, it's really difficult to get waivers on anything with controlled substance. Those are the ones that are much more difficult. If it's other things, 15 to 20 years, we can definitely show, in the more recent years, how that person has changed their character and supporting evidence that that person, is a good person. Sheena says, good morning. Does the 90-day rule apply if you got married in the States, went back home, then returned to the States to file your green card? So technically, guys, the 90-day rule doesn't apply anymore. Like, it's no longer a thing per se. I mean, you always still want to not misrepresent yourself. Like when you go through customs, if they're asking you, what you're doing or whatever it is, and then all of a sudden, you're like, I'm not leaving the country. So, but, people change their mind all the time. Many people come into the States not planning to stay here. And so their intention really is to visit, and then they come here and they change. So, so they look at it in the totality. Do you have a genuine marriage? Did you really come here to see your spouse? And maybe you decided, what, I miss my spouse too much. I want to stay here, and just be here. So there are many variables. So 90 days is not something that is set in stone any longer. Is it safe to travel to your home Is it safe to travel on the paper to your home country? What paper? What are you talking about? Are you talking about advanced parole? I can't really answer that unless I know your immigration history. Advanced parole questions, I know a lot of times you guys ask me that. Those are really difficult to answer if I've never worked on your case or I don't know your immigration history, because it's not just as simple as getting an advanced parole. We need to see your immigration history, what phase or where you are in your case process before I say you can go or you can go. For instance, if you're somebody who has a petition going on and you've received a notice of intent to deny, absolutely you're not going anywhere. You do not need to go, because if they deny your case, you'll be stuck there. If you're someone who has had an interview, and they've not made a decision on your case, I don't recommend it. The only people that I recommend traveling outside with the advanced parole is if this is a brand new, fresh application, squeaky clean, no criminal records, and your case is still in the pending stage, meaning we've not received any NOID, you've not been called for an interview or anything else like that, not called for an RFE, you don't have an RFE. Those are the people that I'm more relaxed with saying, okay, you can travel. Over this December, I mean, when I tell you, like, everyone that went to do Delhi December and like we're traveling all over, the amount of people, and this is not just, I'm just talking about even my colleagues that, their clients like got stuck like in different places because, they didn't verify that they could travel. Another thing that I want to point out as well is that if you're here, let's say you're here on another a visa that's active or that allows you to travel in and outside of the United States, there are very few exceptions to this. You cannot travel once you start the adjustment of status process and you don't have the advanced parole, even though you have something else that will allow you to come back in. So while it will allow you to come back in, it will cancel out your adjustment of status application. So you always want to verify and make sure that whatever class that you're in allows for travel before you do, okay? I got my EAD, but the date of birth is incorrect. Seems like the forms had an error. Will they change it or will I be penalized? So you will not be penalized. You can always reach out to USCIS. I don't know what kind of case you have, but they can fix that. But you have to send your card back, though. That's the only thing. If you don't have like a humanitarian-based case based on abuse, you can usually do an e-service request, just letting them know typographical error. So the first thing they'll do is you can, on the e-service request, you can just type. There's an option for typographical error, then you can put the information in there. And then you want to manually mail your card with your receipt number, as well as proof of your birth to show your correct birth date so that they can fix it. But you basically have to return the card in order to get a new card back. After filing for VAWA, what is the first thing an immigrant gets? The first thing typically that you get after filing for VAWA is a prima facie determination letter. This letter usually comes somewhere between like 3 to 5 months if you meet the minimum requirements. So they're looking at all the different prongs of VAWA to say, okay, on the preliminary level or on the surface, this person meets it, which is, proof of good moral character, proof of some sort of abuse, proof of good faith marriage, or proof that your parent is a U.S. citizen or a green card holder, or your child is a U.S. citizen, and then bona fide evidence, right? If it's based on marriage, like if you have the basics, typically you would get a prima facie, and all your children, if it's based on marriage, will be listed as well. This is not a guarantee of approval. It's a good sign, but not a guarantee of approval because they still have to go through your, your case with more of a fine-tooth comb. And then once they go through your case with a fine-tooth comb, then they can tell you, you're approved or, we need more evidence from you. Okay. And then after that, typically you'll get a work permit and a travel permit if you applied for one with an adjustment of status. If you didn't, you probably will not get anything else until they make a decision on your case, or they request additional evidence, or they send you a notice of intent to deny. I filed for my green card renewal in 2022, and I haven't received anything, and the verification letter is going to be expired in May. What should I do? So when you say you applied for your green card renewal, do you mean that you had a 10-year green card? If you have a 10-year green card and you've submitted an I-90, your I-90 acts as an extension. If that extension is expiring in May, you can actually go online and request an info pass for an added stamp, which essentially is them stamping another green card or green card letters, basically the I-551 on your passport, showing that for the next 1 year, you still have a valid green card. It's just that your case or your renewal is pending. If what you submitted was a removal of conditions in your green card because you had a 2-year green card, you can do the same thing. You can still go get the info pass and have them put the stamp on it. Okay. Let's see. I have a friend of mine who married almost 5 years. He filed his paperwork and did his biometric October, November 2027. I guess you say he did it in November 2027. and he still hasn't gotten his work permit. Can you give me more information? November is not a long time, I mean, it just depends. I mean, they don't really care how long he's been married. They just follow based on a normal time. So depending if he's filing based on marriage, it takes them 4 to 9 months on average. So as long as he's within that timeline, he's still in a normal process and timeline. If he's out of that timeline, then, we can, probably do like an inquiry to find out what's the delay. Sometimes you can do an expedited if you have solid proof of that you meet the requirement of what they consider extreme hardship, and they may consider that. So it just all depends on what the person has. I applied for VAWA last year. Last year, December, I got my work permit and travel permit approved. My question is, my children have not yet been approved of anything. Melania, I love that name, by the way. It depends on where your children are and what you applied for them. So if your children are in the United States, did you apply for an adjustment of status for them? And if you applied for an adjustment of status, did you apply for them for a work permit and a travel permit? If your children are not in the United States, you're not going to get any of those things. The only thing that they're going to have is their name is going to be listed on the prima facie determination letter. And so that when you get approved for the VAWA, then they would get approved. If my I-130 is approved and my I-485 is actively being reviewed, can I travel? Hola Mori, I talked about traveling earlier, and how I refrain from giving travel advice online on live because I don't know your case, but I gave scenarios where I would be okay with people traveling. Can you live with your husband the same while you file for a VAWA case? I think that's what you're trying to ask, but absolutely, you can live with your spouse while your VAWA case is pending. Now, because you're applying for domestic abuse, essentially, you're an abusive spouse or extremely cruel spouse, you want to be very careful with that. You want to make sure that your spouse is not privy to any of your passwords or things or your documentation, because depending on if you don't have a lawyer, whatever, like however you get sent that mail, you want to make sure that you have either someone that can confidentially save that information for you so that when USCIS sends mail, it's not coming directly to your home. Because if you are dealing with someone who's violent and finds out, like, your safety could be compromised. So you want to make sure that you're responsible in how you keep your stuff. Also, for some people, if you get a prima facie determination letter and you choose to get some kind of state benefits, because some states offer state benefits, like, food stamps or cash assistance or housing assistance if you're a victim, on applicant of VAWA. But for a lot of them, the requirement is that you cannot be living with your abuser to do that. And then also, this is something that a lot of people don't know, because we get a lot of clients who are dealing with VAWA, and they want to escape or get out, or they want their spouse out. But a lot of states have they have VAWA laws. This is not even related to immigration, because VAWA is a federal law outside of the immigration portion. It's also a law for even Americans as well. And so where they can remove that person, or they can allow you to terminate a lease, so you can get out and not be held, responsible for eviction. For whatever lease or breaking a lease, if there's evidence that you're in an abusive relationship and you need to remove yourself. This is, very state specific. So, you would have to see what your state real estate or landlord property laws are to know. Okay. All right, guys, I can only take one more question. And then I will go. Is it okay to call USCIS while your case is pending? Yeah, sure. It depends on what kind of case. If it's an abuse case, USCIS does not take calls. They're not going to answer or respond to any call. They're just going to send a letter to the address on file, letting them know that we are not going to discuss anything about the case unless through your attorney or if there's an official letter with your signature and all of that written. And again, this is to protect victims of abuse. All right. This person says, I'm here in the United States because of my health. I have breast cancer. I've been here for 3 years and counting. I also do the extensions every 6 months. My question is, what can I do to stay here? First of all, Queen, I am so sorry to hear that. That's really sad. And I pray that, you recover and you're healed and, everything, you find yourself in remission and in good health. As far as what you can do, you can actually do what we call medical deferred action, and we can help you with that. I remember one of the cases that have been very dear to my heart. There was actually a news article on my client was her 2-year-old who ended up being here because she got, she had cancer. And, just getting so many different diagnoses in Nigeria and then coming here to find out that she had a cancer with a prognosis that wasn't very strong, but by the grace of God, she's active, alive and kicking. And, they're here in medical deferred action. So, that is something that we can certainly discuss and see if you're eligible. A medical deferred action is where USCIS basically, it won't give you a green card, but what it'll do is it'll allow you to stay here in 2-year increments with an ability to have a work permit if you need to work. But that way you're in a period of authorized stay here until, you finish your treatment. Okay, guys, I will be on live tomorrow. Let me check my calendar real quick. I know some days I say I'm going to be live and then I realize that I have a meeting that was scheduled that I can't change. Okay, so tomorrow I'll be on live at 10 a.m. So if I didn't get to your question, come on tomorrow. I'll happily answer as many as I can. I hope you guys have an amazing day and I will talk to y'all later. Bye.